Shirupa and Anisha. Shirupa on the business side and then Anisha moved into other areas. She now edits our VC World, which is our private equity site. And Ashima edits, Ashima and Krishnendra edit BW Legal World, but Ashima's father-in-law is unwell for the last 8-9 days. So, and Krishnendra is recovering from COVID, so he doesn't have the enough energy to be so.
Sir,
Anisha and me have been. Okay, thank you so much. Anisha, why don't you start? Good afternoon. Let me invite you to our first BW Legal World webinar this year. BW Legal World has been around for the last 20 odd months, and we've done 6 IPs in this domain. Today we discuss intellectual property rights and how the landscape is changing. Are the laws keeping pace? How are the various stakeholders being impacted in a digital first scenario? To do that, we have a set of experts who understand IP laws, advise clients, and are also giants in their profession. Let me welcome all our panelists who are leading legal experts. My colleague Anisha Aditya, who is an editorial lead both at BW Legal World and at BW VC World, will introduce all of them. The luminaries, I would bring in Anisha now to introduce them. Anisha? Anisha?
Hello.
Yes, Anisha.
Yes, good morning, everyone. Today we have Mr. S.N. Sobhan, Managing Partner from O'Connell Associates. We have Mr. Amit Datta, Partner from Sai Krishna and Associates. We have Ms. Petal Chandok from Trust Legal Advocates. We have Mr. J.B. Abhay, Partner Shardul Amarchand Mangaldas. And we have Mr. Nishad Nadkarni, Partner at Khaitan & Company with us today.
Thank you so much. Anisha, why don't you start with the first set of questions, give a context into what we are discussing and the contours of what we'll be able to achieve at the end of 60 minutes.
So we'll be
Anisha?
Yes, good. Yes. Am I audible?
Yes, Anisha, you are.
So we'll be discussing the significance of the copyright issues in India today regarding the various relevant issues related to the Indian Copyright Act, along with the rise of various digital artists in India. So the first question we'll be asking Mr. Nishad Nadkarni. On the surge of various digital artists in India, in platforms such as Instagram, Spotify, Netflix, Amazon Prime, there's been a rise of consumers in the ebook reader section. So, Mr. Nadkarni, can you tell us, has there been an increase recently in copyright-related issues in India?
Yeah, hi. Thank you, Anisha. It's very good to be here in the morning today. I think I hope all the listeners today are keeping well and safe, and their families are also in good health. I guess, when we are talking about the digital space and digital artists generally, or even digital works, they've been around for a good amount of time. And it's only because of the fact that we are now relying more on the digital space, digital media, because we are not going out, because we are at home, that I think a lot more attention is being drawn towards the digital space. The issues which have arisen have been continual in nature, but probably, have got more precedence now, or are being looked at more closely now, because there is a lot more reliance on this form of data. Now, there are two aspects that come into play when we are talking about digital artists or digital media or digital art or digital works generally. One is, I think, the creation of work, and the second is exploitation of already existing work, both of which I think take significance. It's a very broad, vast topic. We have limited time, and therefore I think I'll just touch upon 3 main or key issues which I've come across during the course of my practice, questions which are asked by clients on a regular basis. In the context of, I think, digital artists, a lot is happening in the space of social media influencers. They create a lot of content which is going up onto platforms like what you mentioned, say Instagram, say Facebook, YouTube, etc. And many entities are now, looking at using this content for the purposes of marketing. Now, when you are creating these kind of content, it is normally audiovisual content, which is composite work. So a lot of other work also goes into creating the content, right? And therefore, you may be looking at works which are already created, for example, music which is used in the background, And ultimately, when you're using this content for the purposes of your advertising, the company, which is our client, for example, may end up using that video on their website or on their social media handles and posts. And therefore, inadvertently or explicitly, they are utilizing that content. This can result in issues arising out of claims made by owners of original content, which is put into this content in the form of unauthorized use, etc. So when you are entering into contracts with these digital artists, social media influencers, you have to be very careful about what content is going into this content which is created. The second thing is, when you are these platforms also offering you any form of protection upfront? Yes. So platforms like YouTube, etc., have come up with digital rights management systems. So they enable content owners to actually register their content with them, and then whenever any content is uploaded on, say, a YouTube, there is an automatic check which is undertaken, and these infringements or unauthorized use, etc., is identified and intimated to the owner, and then it's up to the owner to either monetize it or call for a takedown, or otherwise just sit back and see where that content is heading. The third part is about enforcement. Now, this is an aspect which has really been around for quite some time. We all know about John Doe orders, where we are faced with unknown infringers. So someone's just come up with a songs.pk, which is the most popular example during our times, at least, where a lot of digital content in the form of music used to be uploaded. And then the government used to ban songs.pk, and then there used to be a songs.pk2 and a pk3 and a pk4. So there's what is the remedy for this? So there's a novel form of an injunction which has come up. It's still developing. The Delhi High Court has been instrumental in implementing it in the Indian scenario also. It's called a dynamic injunction. What do you mean by a dynamic injunction? An injunction is granted against an infringing website, for example. The same person or a related entity comes up with a mirror website or another extension of a website, like songs.pk2, etc. Then there is an ability for the plaintiff to approach the court, make an application simply to the registrar, implement that new website, and extend the injunction to the new websites as well. Therefore, the injunction is dynamic in nature. It's fluid in nature. I think these are the 3 points that I wanted to.
Yeah. Thank you so much. Anisha,
quickly.
Thank you so much for bringing these aspects. While we'll post specific questions to everyone, what I'd like to do is to get everyone to make their opening comments and then really get into specific question. And my follow-up question to you would be, has the IP litigation, especially in the last 15, 16 months, increased? If yes, by what quantum?
Well, this is a slightly complex question, I think. Courts have been working in the digital domain as well. There was a short span of time when physical courts had started and litigation had again picked up. But today, courts are really limiting matters to really important questions of law. In that context, I think digital media-related litigation has been around. It has increased to quite an extent. But I think most of the litigation that may be happening in the IP space is with regard to maybe pharmaceutical substances, in addition to, say, digital media. And I think most of the digital media litigation is around content-related disputes, maybe scripts of new web series coming up or movies which are being launched online, etc. But I wouldn't say that there's been a significant upsurge in litigation mostly because the infrastructure is not so strong today to kind of handle online
Understood.
hearings throughout India. It's mostly in the high courts.
Understood. Let me bring in all the panelists because you all have a point of view and you practice in this domain. Let me first bring in Mr. Amit Datta to make your opening comments in terms of how's the landscape changing. What is your view? And especially, how do you see the future unfolding? How do you see the laws keeping pace? What are the top 2-3 trends? So I'd like each one of you to be able to share your opening comments and then we'll get into specific questions. Mr. Datta first.
Thank you, Mr. Batra. Good morning to everybody. I think primarily 2020, 2021 until now has had a significant effect on the TMT space or the media and entertainment space in significant respects. I think the first aspect is that it's really knocked the idea of traditional business models in terms of the media industry. So if you look at the film industry, it's knocked the window system of release off the perch where it's OTT release now directly. If you look at music, it's really affected the relationship between music labels and creators because creators feel increasingly that go-to-market is directly served through social media websites like YouTube, etc., and they could be served better. There's an increased focus on taking ownership on the publishing side, which is shown by the recent purchases of the Bob Dylan catalog, Neil Young catalog for hundreds and hundreds of millions of dollars, which shows that music labels and groups, music groups, ownership groups are aware that publishing is going to become a big focus across the world. I think primarily as well, I won't call them new business models, but there's a reinvention, in terms of self-publishing, which was never a popular alternative for artists and creators. That's now become, an alternative. Because of COVID, because of lockdowns, because of containments and restrictions, you have the death of what was known as the live entertainment industry, which has now led to the creation of online live events, slowly, from being free concerts to ticketed concerts. BTS did worldwide, the Korean supergroup did a worldwide concert. Various other artists are doing worldwide concerts. So there's a change, I'd say, in the business models. There's a focus in the online space for revenue, which is likely to lead, as Nishad said some time back, an upsurge in litigation around content ownership, licensing, the contours of licensing, and the extent of rights that have been licensed. So with the focus on revenue, shifting from traditional physical performance, physical industries to the online space, which by all accounts today accounts for, say, 85%, for instance, of the music industry's revenue, to even 90% in some cases, in some territories. There's a focus on revenue. When there's a focus on revenue, interpretations are likely to be more sharper, more aggressive, and there's going to be likely references to courts. And I think finally the focus again has now shifted back to some extent on creators. They are front and center, and what creators do and how they engage has now become, earlier it used to be a marketing ploy or a marketing buzzword with websites or services like Spotify and the rest. But now it's become a more important sort of engagement, direct engagement. So that's kind of led to kind of significant changes in how the media and entertainment business operates. Where litigations are concerned, I'd say there's been a drop in absolute numbers in terms of litigation, because obviously anti-counterfeiting, with the volume litigation, has fallen significantly because of the restrictions, the physical restrictions imposed by COVID. But there has been an upsurge in terms of absolute value. So IP litigation, for instance, patent litigation in the telecom space, or content litigation for licensing against short video websites, etc., has grown. Those are high value litigations ending in high-value licensing opportunities, both for copyright owners as well as for short video services. So there's been that sort of trade-off where the absolute numbers have certainly fallen. You had hundreds of litigations being filed, now you have lesser number. But I'd say to some extent, the value of litigations have increased. What has also increased is, and which has been circumscribed by the rise and fall or the ebb of the COVID sort of pandemic, has been litigations around copyright creation, copyright exploitation, focused on Mumbai in terms of scripts, as Nishad again correctly said. And I agree with that, and script ownership and remake rights and et cetera, where people are more, kind of aware of the rights they have or are more aggressive about seeking to monetize what they have, which they wouldn't have done. I won't say use the word boom time, but in a normal
times,
they wouldn't have been that aggressive. They are now more aggressive. So there's been that little shift. But I'd say fundamentally the media entertainment industry the focus has shifted from the traditional television and radio. I think the days of radio are numbered, unless this go to internet radio, where television is concerned, it's under stress because it's still price regulated, whereas on the online space is not price regulated right now. So there is definitely an upsurge there, and you can see that by television industry putting an equal focus in the OTT space as well.
Absolutely.
Transferring content literally same day, same time.
Mr. Datta, I fully agree with you. Being in the media space and business world is my second venture. I did found Exchange for Media. So the only domain I can claim to know a little bit about is the media domain. So I fully agree with your thoughts. Plagiarism is an issue. Ownership is an issue. Website copyright is an issue. Creative Commons freeware and shareware is an issue. Length of the copyrights is an issue. Breach of copyright abroad, because with internet, what is the territory is being redefined while it's becoming sharper in definition. And last but not least, what are the exceptions, to these? So we'll come to that, but let me bring in Ms. Petal Chandiok into the conversation. Petal is a partner with Trust Legal. Petal, give us your opening comments in terms of where do you see the copyright laws coming into motion and how are they keeping pace with the fast-changing digital world?
Yes, thank you, Dr. Batra. So, as rightly put by Mr. Datta, that there's a lot of focus on digital now with the lockdown, with COVID, and in these times, and which is why there's a lot of awareness of each that each person has of their own copyright interests and their own rights. So yes, that has really led to a lot of understanding, a lot of I would say a sort of an upsurge also, where people are wanting to really protect their copyrighted works, be it patents, be it anything. And with the increase in this digitization of everything around us, how everything is OTT now and it's all digital. So yes, a lot of focus is on protecting one's copyright. In fact, there is a lot of interest in amongst the stand-up comedians, where they are wanting to really protect their own copyright, how they create their content. So this is one thing which unfortunately is not as such protected now, but they as an industry, or they as a sector, is also looking at how they can protect what they create, and certain memes that they create, and certain stand-up performances that they create. So even they, and even a lot of such groups, have started to think how they can protect their works in the coming times. And I think, of course, with our copyright laws also evolving, and of course, there are certain provisions which are still being interpreted before courts and are sub judice. But with that being done, I believe there is a lot of scope of protecting these copyrights, b having a lot of maybe in the coming future upsurge in more litigation, because as people get aware, they want to protect it. And once that happens, I think, yes, it also leads to a lot of commercial, like Mr. Datta said, a lot of massive commercial engagements are, license arrangements are being eventually created, eventually formed. So yes, this is what I feel is happening in the copyright domain as of now, and let's hope that it goes this way. And yeah.
Okay. One of the statistics, while both Mr. Nadkarni and Mr. Datta talked about the fact that prioritization of cases is happening and the caseload is limited, so we are not seeing that much litigation. But one of the important ways to look at it is the number of copyrights filed has gone up tremendously, and I want that data from someone. But let me bring in Mr. Oban, and then we'll bring Mr. Abe. And Mr. Abe, in the second round, we'll start with you. So someone has to be first, someone has to be last. They say reserve the best for the last. So let me bring in Mr. Oban. Mr. Oban, your opening comments in terms of what are the changes that are happening and where do you see the copyright regimen headed?
Thank you, Dr. Batra. Thank you, Anisha. So I think Amit, Nishad, and Petal have more or less, highlighted the key trends. But just to add to that, something that I've been seeing for the last year and a half, is this tremendous push towards monetization, towards creating new, unlocking new value, towards finding new sources of revenue. And the fact is that I think everyone in the digital industry is largely looking at, where do we go from here? What are those new revenue streams that we can look at? And a classic example of that, I think, is what we're seeing in the NFT space. And NFTs, they came by storm. Who would have thought that the popular artist Beeple, who first sold his mutating Donald Trump GIF, a small clip, for about $60,000, which then went up to about $6.8 million. And then I believe last week, finally traded for about $69 million. Now, what that shows you, I think, is there will always be collectors. And as far as the digital art, painters, that space has traditionally not unlocked this value. And you'll have collectors of cards, you have baseball card collectors, you have people who collect Raja Ravi Verma prints, 1 of 100, 2 of 100, etc. And the underlying challenge has always been that how do we know this is real, right? So even in the art space, you have huge works by masters, which quite often we find that we're not really sure that this is an authentic piece of work. Now, the classic story on that is there's this famous gallery in Delhi that acquired a set of Raza paintings, and they checked what every gallery in the industry does. They checked the provenance as best as they could. They looked at who bought it, etc. And they were so confident that the works were original that they hosted a show and invited Mr. Raza himself to come for that show. And he comes and he says, I don't think these works are mine. And that kind of goes to show you that there is a problem in that industry. And we are now seeing certain trends using blockchain to try and, get like a crypto-based provenance of an artist. And a lot of the younger artists, one can see, are using that as a platform of generating authenticity, of generating provenance, of generating uniqueness, all of which, in my view, is unlocking a lot of value. But we can talk about it as we go along.
Just to build on what you said, in the last 1 week, Bill Gates has been in news. An optimist would say for good reasons, pessimist would say not so good reasons, but the house that he was building, even then he built a smart home 25 years back. And his idea was to be able to have these digital pieces of art. And as you know, he's very aggressively acquired for the last 2 decades, most of the digital art which is substantiated. So he's been a big collector. And clearly Bill Gates does see things happening before others see. So if he's invested in something, clearly there is some value there. There is some traction there. So I just wanted to support your point. But let me bring in Mr. J.V. Abe, who's a partner at Shardul Amantir Mangaldas, for his comments and bringing some more fresh light. I know you're last in the introduction, so some of the points you may want to make may have been covered, but I'm sure you'll still bring in some new dimension. And what I'd love to know from you is, the quantum of copyrights being filed from your own standpoint? How much has it gone up? Give us a sense of the proportion.
So thank you, Dr. Batra. Most of the points have actually been covered by Amit, Nishad, SNEs, and Petal. What we have seen is actually due to digitization, new applications coming in, which encourage people to kind of make new work and which act as direct revenue sources. So since this is a kind of an encouragement which has been given to the artists, the kind of misuse of such work has also kind of increased, even though the litigation has not kept pace for various reasons. Primarily perhaps due to the lockdown, where only important matters are being taken up by courts. The high volume in terms of the monetary considerations of the litigations have gone up, but the actual number of litigations have not gone up. In so far as filing of copyrights is concerned, it has risen. I wouldn't say dramatically, but yes, the numbers have increased in my experience, whatever I have seen. The primary issue which I see in the digitized world of copyright is the revenue which is being generated, which will lead to misuse, and which gives us an idea of the fact that there will be more sustained litigation in future. So I think even though at present the litigation, the numbers in terms of numbers, the litigation may not be high, but going forward, I think it's just going to increase.
Okay, that's a foregone conclusion that it will happen. I want to ask you one more. Now, as this landscape changes, and as Mr. Datta and Mr. Nadkarni in some way alluded to the fact that COVID has been a chief digital transformation officer, or the virtual economy is growing because of COVID, because all of us are spending time in our homes and we're using virtual ways to do whatever we would do in old time. So give us a sense, Mr. Abhay, in terms of what are the copyright laws that need to be in some way upgraded, or the thinking behind these laws that need to be upgraded, because the context may have changed in a lot of cases. I would want your inputs on that. What needs to change to be able to be relevant for now and the future?
Look, as of now, according to me, the Copyright Act deals with most of the issues, whether it be arising out of the digital world or otherwise. I don't see many places where the law needs to keep up, because the law as it is can be enforced and interpreted to cover most of the issues which come up. For example, when we were talking about, when SNEs was talking about the NFTs, for example. So the Copyright Act does provide for a resale royalty, which artists perhaps don't know about, and which can be very well kind of categorized under the blockchain, because every resale would be categorized. So even though artists perhaps are not aware of the right itself, but what can be done is under the blockchain, the subsequent resale would be recorded. So it's easier for them to enforce the right which already is there under the Copyright Act. So that is my view as of now.
Thank you so much for saying that the current copyright laws, in the way they are working for now. They need to be implemented in spirit. And both Mr. Datta and Mr. Nadkarni and then Mr. Oban focus on the fact that revenues from digital are likely to be a bigger focus, and hence the copyrights and the expanse of them and how they are interpreted will become more and more important. Anisha, I would hand it over to you for the next round of questions. Back to you, Anisha. we are visible
Mr.
and yeah, go ahead.
Yes, yes. Mr. Abhay, I have the next question for you. Can state and central governments use copyright protected materials without permission? And can you share your opinion on that matter?
Well, look, there are two parts to this. First is under the Copyright Act, and one is under the doctrine of eminent domain. Under the Copyright Act, you have Section 52, and specifically Section 52ZA, where the state or the central government can use the performance of a literary, dramatic, or musical work or communicate it to the public in cases of an official ceremony which they hold. Secondly is the doctrine of eminent domain, where the state has the power to take over property from individuals. This primarily is basically based on the fact that the sovereign can do anything if the act involves public interest. So the basic idea behind the concept is of public interest, particularly national interest if it is involved. For example, if anything is required for public use. From the doctrine of eminent domain, you can also kind of look at compulsory licensing. We had the super cassettes case wherein the court reiterated that the requirements in terms of intellectual property, that copyright was a property within the meaning of Article 300 of the Constitution, and that compulsory licensing under Section 31 of the Copyright Act should satisfy the requirements stipulated under the Act, and any kind of a deprivation which happens must happen pursuant to a valid law and should satisfy public purpose. So these are my kind of comments on your question.
Ms. Chandok, would you also like to comment on this matter?
Yeah, thanks, Anisha. So, of course, one is the fair dealing part, which Abhay has very rightly covered. Of course, even in fair dealing under the copyright laws, we need to see how the state and central are actually utilizing these works, and in what manner are they being used, what is the extent that is being used, and whether it's being used for some sort of a like he mentioned that whether it's an official purpose or what exactly it is. But definitely it does get covered under the copyright laws under fair dealing, and not just state and central but also otherwise. When we talk about an infringement, there is a doctrine of fair dealing where if there is any violator, he can sort of take an exception of fair dealing doctrine. But yes, again, the aspect of how it is being used, where this work has been used, and in what quantity is something that usually is looked into. And even so, in a lot of cases, this exception has been given. In fact, one of the famous Oxford cases where the books were photocopied by these DU photocopiers, and that was also covered under the exception of fair dealing, where it was said that it's more of a student and pupil dealing, and therefore it cannot be considered as a violation or as an infringement. So yes, definitely, not just state and central, otherwise also this fair dealing concept or the doctrine can be used when we talk about any sort of copyright infringement. Uh, but to what extent, and all those exceptions and parameters needs to be looked into under Section 52. Yes.
Right. Thank you so much. Mr. Oban, we would like you to maybe say your opinion on the matter, that are there any specific caveats that need to be resolved in the Indian Copyright Act of 1957?
I'm sorry, are there any specific caveats you said? I
Yes.
missed
Do you
your.
think that the act that the legislation further needs to be developed, considering that there's been a surge of digital artists in India at the moment?
Yeah. So, I'm going to answer that in view of what I discussed earlier, that given the surge in NFT, given the surge in use of blockchain uh, for authenticating art, for generating provenance, and given the very nature of NFTs, where what you're really doing is you're passing on a version of the underlying work, but not the work itself. Uh, the question then is what happens where if the artist himself does it, that's great. He's perfectly within his rights to do so. But what happens where those adaptations or derivative works are created by third parties and uploaded on platforms where quite often such uploads are anonymous? I see some of those issues that perhaps we may not find immediate clarity in our act. Similarly, when you talk about the new models that are coming up, right? And perhaps Amit, who's really a master in this space, should be able to answer that. That what happens where at a live event or at a live concert, I take a selfie with a celebrity, or I take a short clip, perhaps a few seconds, and I tokenize it and I create an NFT out of it. Uh, am I within my rights to do so, or am I then, basically infringing or trampling over the rights of the celebrity or the personality whose photograph or even say a certain motion or a small clip that I'm using? So those are issues that I think will need to be resolved, and maybe some of the other panelists have a view on this.
Mr. Datta, I wanted to ask you, you said in your opening comments that creators are finally at the center of it, or even if not at the center, they're becoming more and more important. And traditionally, the copyright laws, especially in the creative domain, especially in the TMT domain, have existed to be able to bring the due uh, uh, rights of the creators. But over the last 20 years, possibly we could have done it better. But you've now said that the creators are becoming central to how this ecosystem is evolving. Can you give some examples in that context and take us through how do you see the future journey?
Sure. I think immediately one immediate takeaway is this upsurge of individual or self-published music labels started by most of the well-known performing singers or performing artists in India, who started their own labels and are now publishing their own original tracks. So what's actually, to some extent, I'm not going to say or argue that it's actually replacing the traditional, say, music industry, but what it's certainly doing is giving space to content aggregators, like companies like Believe, etc., that are now aggregating content on behalf of creators who create and self-publish their own content, and then engaging, kind of monetize that content on their behalf, and thereby putting the content creator in the in the center. The other aspect is obviously where the creator himself becomes close to the platform or to the to the market facing window, so to speak. Then it's inevitable that the creator then becomes a force or has a role to play, as opposed to traditional mediums where they were several arm's lengths away from the windows of exploitation. And so that again has had its own impact. There is a dissonance. An example I am fond of giving is the valuation of Ghana.com recently after its 50 million funding at $530 million. And then you compare that with the valuation of the Indian music industry. And mind you, Ghana.com, its own whole raison d'etre is music exploitation, that the entire valuation by consensus does not exceed $170 million at any given time of the day of the entire Indian music industry. So you can see the lopsided sort of dissonance there in terms of the value recognized or realized by platforms vis-a-vis the creation and the content generation business or individuals. And that is going to come under pressure and has already started coming under pressure. The United States has relooked at royalties that are payable. It has recalibrated royalties as litigation, appellate litigation that is currently going on. In fact, royalties that were increased by 40% and 42% last year ahead of the COVID crisis. And so that trend had already started. So you are going to look at, you're going to see a lot more, and that brings the focus on publishing back into India after 2012. The objective was to give a measure of the realization of revenue to creators, and that's been pushed back on by various platforms. Various platforms have agreed and have complied with the law. Various platforms, come out with interesting interpretations of the law and how they want to construe the law, and in an effort that in order to argue that the creator's position has still not been recognized. Without going into the merits of those, the fact is that India has treaty obligations, and there was a time when India and Indian courts could say that municipal legislation will trump our treaty obligation. But given how inextricably we are linked to the global economy, I think their time is running out, where India can say that I will sign treaties, but I will not honor those treaties. So from that perspective, again, there's going to be pressure, and there is going to be pressure now, particularly given that India's kind of political alignment also is on the side of, you're looking at the Quad, you're looking at a pro-US, pro-Europe alignment away from China, and that limits our space as well. So, kind of acceding and then complying and enforcing those treaties is going to kind of to some extent change the landscape where the copyright space is concerned.
Thank you so much. Mr. Nadkarni. Yes, go ahead, Mr. Bhatt.
Just, not specifically a change in the Copyright Act itself, but one of the changes that I think needs to happen soon is clarity on, India's position on cryptocurrency. And the challenge that I think most artists today are facing, and there's a very popular Bangalore-based artist who recently sold his GIF and an NFT of his GIF for about 2.5 lakhs. And a lot of questions are being raised as to whether his trading on crypto violates Indian laws, and is he really allowed to do so? Now, and I think till we clarify those issues, we're not really going to encourage Indian digital artists or even just artists to release what they would like to release in the digital space. And a good example of that also is the King of Leon's, it's a music label, it's a music band, recently launched their first album actually as an NFT. And you could get the unique rights to that NFT by using crypto. Now, given India's, especially the RBI's hard stand against crypto, it would be useful if we could clarify this aspect at the earliest.
Absolutely. And, Mr. Nadkarni, right up front, you, in your opening comments and the questions asked by Anisha, you brought out the point that while creators matter and TMT matters, the focus is right now a lot on vaccines, pharma, saving lives. So the last 2 weeks have been dominated by discussion around whether the IPs around pharma should be open. And I heard an interview on CNN of the South African president last Sunday, where he talked about the vaccine apartheid. He said the fact that South Africa is not being able to get enough vaccines for South Africa and the Western countries are not doing, it's akin to apartheid, and he used the word vaccine apartheid. In that context, where COVID and the vaccine need has created haves and have-nots in terms of countries, how do you see the IPs around vaccines? And again, ICMR has clarified its position last week on what its view on the vaccine IPs is. Where do you see it as headed?
It's a slightly complex question. I must say, I'm not basically a patent practitioner. I've litigated some amount of patent work, but just to give you my view on this, what has happened is the vaccine technology has been created by certain entities, right? Now, it may be created in, say, India or US or the UK or several other countries. So the base IP, if I may say so, would normally vest with the entity which has created it. Okay, just to give you an example in the context of litigation or the public interest litigation which is happening in India just now before the Delhi High Court, and of course the suo motu petition which has been taken up by the Supreme Court as to whether there should be more imports, should there be a compulsory license granted, etc., etc. Now, what is happening? Just to give you context in the Indian scheme of things, for example, today the tocilizumab medication, for example, is being imported into India. Now, the medicine is really meant for rheumatoid arthritis. It is being applied to COVID circumstances. It's not a medicine which is meant for COVID. It is applied to it because they've seen certain improvement in patients. Whether it actually works or not is something that I personally don't know. Now, because of the fact that it has been significantly used, there is a shortage of that medicine. The courts are looking at importing that into India. Now, the patent vests with Hoffmann La Roche. The Indian entity is merely a licensee. Now, the Indian entity is being kind of pulled up before the Indian courts and is asked, how much are you in a position to satisfy the demands? Now, I am not sure whether the Indian entity is in a position to answer that question, because the entity which holds the patent, for example, may have other obligations in other countries. There are various other contractual obligations also. Are you in a position to therefore then force an entity to make additional supplies into India without knowing what other obligations they have, without knowing what is the manufacturing capacity? You may probably then be in a position to kind of give out compulsory licenses, but then there are other practical questions. Now, when you are talking about the specialty drugs, there are requirements with regard to manufacturing these products as well. There are requirements of having specific manufacturing capacities, specific circumstances in which they have to be created. Not everyone has that infrastructure. So when you are granting these compulsory licenses also, you will have to examine whether that quality of the product which is actually required by these jurisdictions is going to be made available to them, and whether these entities who are wanting to or looking at creating these medicines have the ability to create that. Yep. There are several complex questions, I think, which are involved, and I don't think it's a simple answer ki bhai compulsory license de do aur khatam kar do usko.
Yeah, I think what we've dealt with the last few weeks is unprecedented in the true word of it, and we are dealing with a VUCA world, and that VUCA world applies to all domains, all sectors, of course, life. You were making a point. Go ahead, make up that point.
Yeah, I was saying that, look, that statement that you referred to, I think has to be looked at in light of the joint proposal that India and South Africa made, asking for the waiver of IP rights during this pandemic. Now, I think the optics go of that waiver, it sounds great, right? So why are companies profiteering during the pandemic and so on? But practically, it's not the solution. Now, the only reason why that waiver makes a little bit of sense to me is, as Nishad also mentioned, the challenge is getting your raw materials. Now, you may need raw material from a country where that raw material may be protected by certain patent rights, which then impacts your supply chain. And so the simpler solution is that you temporarily, maybe just suspend IP rights and you source your raw materials. But I think that's a very naive view, simply because the challenge again is not the raw materials. The challenge is the know-how and the ability to actually start ramping up vaccine manufacturing.
Exactly.
And these guys, ICMR, like you said, just clarified that they are they are welcoming people to come and take their recipe. This is something, in my view, that we should have done long back. That you had your own vaccine, that you have some facilities that are lying vacant in India. You could have very easily shared that recipe made arrangements for raw materials and ramped up vaccine manufacturing much earlier, rather than go around the world asking for IP waiver rights. So just my view on that.
Thank you so much. Anisha, back to you. Anisha?
My next question is to Mr. Nadkarni. So there are various DRM measures that are being adopted by various platforms like YouTube to assist the owners of copyrights in preventing any kind of infringing copies that are being imposed on their platform. So can you speak a little bit on the various DRM measures that are being adopted on YouTube? You have to unmute yourself.
Yeah, sorry. So as I indicated in the beginning, I don't think there is much more to add for me from what I indicated in my opening comments. But yes, most of these platforms are providing for a registration of your IP. So if you have created content, then there's a repository which is being created by platforms like Facebook. Platforms like YouTube. And what happens is whenever you are creating content, then there's a matching process which is conducted, and then your owners are intimated of the use of your content within a content, or for that matter, simpliciter posts. Just to give you an example in the context of these webinars which are being conducted, once the pandemic started, there was a surge in the amount of webinars which were being conducted, etc. So in the context of your webinars, it's very important to keep the audience engaged, and therefore a lot of videos, audios are being used, right? And ultimately what happens is these sessions are also recorded and then they are posted on YouTube, for example. Now, one such session was being conducted by a colleague of mine, and he has a habit of giving good examples, keeping the audience engaged with live examples, and therefore some music videos were also used in the context of the webinar. And once it was uploaded on YouTube, there was an intimation which went out immediately saying this content is protected by copyright. And the owner of the copyright will have three options: A, to monetize it, which is get a share; secondly, just sit back and see where that content is headed, and then probably take a call as to whether royalties have to be paid out; and thirdly, of course, copyright strike and take down. So that's the way I think things are functioning today. And the copyright owner, therefore, has the ability to decide what happens thereafter.
Absolutely. And can I tell you, see, I understand that sometimes the material we use, because we create content, so we are very conscious, we take permissions, we write, we seek clarity so that we want to inform the person, we want to give credits. And I want to tell you personally, I post every day on social media platforms. And I made it a point to say that 90% or maybe more of what I post is not original. It's, it's a thought that you sent me, Mr. Nadkarni. I liked it and I posted it. And wherever possible, I'll either tag you or at least give you credit wherever I can find the person. So because we ourselves create content, we are very conscious of the fact that we need to give credits where due. Back to you, Anisha, for further set of questions.
Yes, so my next question is to Mr. Datta.
Yes, Anisha, go ahead. I know.
Hello?
Yes, Anisha, we can hear you.
Yes.
Yeah.
Okay. Yes. So considering that there's been a rapid expansion of the tech industry in India, do you think that new ideas, methods, and systems that are building an MVP, which is the minimum viable product, can be brought within the purview of the Copyright Act? Is that a possibility in the future?
I think traditionally the Copyright Act defines certain classes of rights or works, or kind of has traditionally defined property rights in terms of certain classes. And if NFTs by their construct fit into a definition, say, of an artistic work or of cinematograph film or a sound recording, then it inevitably will have that sort of definition. But I am completely open to the concept of copyright being sort of rediscovered or relooked at, because there are quasi rights which have which perhaps the traditional Commonwealth system or the French authors' rights system did not kind of have in mind when they looked at copyrights. I mean, examples of these rights, if they are not kind of property rights, but rights or actionable claims, are already there in our Copyright Act system. The authors or the artist's resale right, which has never been exercised in India, but it is a worldwide phenomenon under Section 53A, where an artist or his or her legal heirs can claim up to 10% of a resale value of an artistic work, or even the moral right, for instance, or the author's special right, which are claims, actionable claims which have been granted. They don't have the trappings of a property, property right, but these are claims. So I think there's adequate room for the Copyright Act to be sort of relooked at and kind of expanded. My worry is that the Copyright Act in its current form is not being exploited and not being complied with, as it should be. And I think the problem is very typical, to India. I mean, you will have cases going to court, which will be types of cases which would never go to court in the United States or in the UK, because the party knows that I might as well as settle outside than have this matter go to court, because I may be taken to the cleaners in court. But the nature of our litigation and our litigation system allows parties to actually leverage the litigation system, in their favor as well. And I think that kind of impairs the entire objective of the Copyright Act. Examples are, for instance, a benefit granted under 31D, which no right owner likes, a statutory license, but which was granted in 2012, but was finally only exercised in 2019. I mean, that's beyond pathetic to have, a privilege granted under a law, parliament-made law, and for it to actually be negated because the judiciary was slack and the government was asleep at the wheel, and they decided that they don't need a tribunal. And once the tribunal started working, now they've wrapped up the tribunal and said everything will go to the courts, without even considering that what they're effectively saying is that 600 district courts, or each of which will have a commercial court, will be empowered actually to grant a statutory license. Not realizing that you need one rate court in the country, not 600. So I think, that we first need to get our act together. Actually, if we published a national IPR policy, frankly, I honestly, with respect, would put more value on toilet paper than I would put on the national IPR policy. The national IPR policy is not worth the paper it is written on. It's a smattering of gibberish and rubbish, and which has objectives which were never intended to be achieved, which were not achievable, and which were pipe dreams. And so we are at a situation where we are fond of talking about, how the copyright law needs to change, etc., etc. But we don't have the systems in place to enforce the copyright law that we have in place. Can you consider that India is perhaps the only country in the world, literally the only country in the world, where radio industry and platforms can argue, or are arguing even today, that I don't need to pay the artist the publishing share. Literally the only country, despite being a signatory to the Berne Convention. I'm not talking about in interpretation. I, in 22 years of my practice, have never seen an articulation, policy level, of legislature or government saying we are not going to recognize the publishing rights regardless of our accession to Berne. Now, this is a court-driven interpretation, inane, insane, and immature, and completely overlooking how Berne has been implicated and enforced into law in India. But we are still at that phase. So until we get at least our Copyright Act aligned, I'm sorry to say, to the 19th century, forget 21st, 22nd century, I mean, let's put that aside. First, let us align with ourselves. What Asinis was talking about in terms of the Patents Act, for instance, and this goes to IP. We are not aligned. We had a 1974 Iyengar Committee report. The whole Patents Act was brought into play, which created an Indian pharma industry. Compulsory licensing has been used before. We still don't have an articulated vision about how healthcare is to be looked at in this country and how access to medicines is a priority or not. So, I mean, I think the objective should be first to enforce the damn laws that we have in place. And then we talk about, expanding it to greater things. We'll be bringing in AI and NFTs, I'm sorry to say, into our law, but we will still not have a working Copyright Act. That's my fear.
Thank you for being provocative, Mr. Datta. We need that. And this is the time to reset everything, reset our thinking, reset and upgrade our ways of working. I'd like to bring in Mr. Abhay and Ms. Petal for their closing comments. First, Abhay and then Petal. Abhay, you heard Mr. Datta, you heard Mr. Oban, you heard Mr. Nadkarni, and they made some provocative comments. I'd like you to make some closing comments now, Mr. Abhay.
Look, I completely agree with what Amit said, and I had indicated this when I kind of made my initial comments that we need to enforce and kind of spread awareness of what we already have. We might talk of digitization and bringing things in perspective in terms of what the developments are and how the law has to evolve. But what we have to look at present is to effectively enforce what we already have. And especially when we talk about artists, there are several provisions of the act which the artists are still unaware of. Those are rights which they have, but they are unaware of, and they kind of do not want to enforce those for whatever reasons best known to them. So I think till the time we don't kind of effectively enforce what we already have, till that time, I don't think we should look at kind of expanding the scope of any legislation. That's my view.
Thank you so much, Abhay, for making those comments. Petal, your final words.
Yes, so Dr. Batra, as already shared by all of the stalwart speakers, I think yes, of course, there is a lot of scope on implementation. Like Mr. Datta said that even our RJs, like I personally represent a lot of RJs in the country, and I think what they have created themselves as you can say authors or creators, they don't have a right to protect that. None of the radio stations or none of the companies, entities are actually entitling them or giving them that right that, you can protect it. So, of course, the rights of these authors, or the rights of these creators, if you may say, yes, there is still a lot of scope where they can, really implement their rights, essentially. Even when we talk about the author's right to receive royalties, that is something which is a sub judice matter before courts, how that needs to be implemented or whether not. So a lot of interpretation is still something which is going on by the courts in the country. And I think, yes, of course, there is scope of also expansion to like what Anisha was mentioning, MVP, how we can protect MVPs is also protecting the algorithms, I think, maybe because still the product is created. Before that, at least you can really protect the algorithms. But yes, implementing what is existing right now, and yes, maybe looking into some sort of amendments in the coming future, which anyways is being looked into. I think this is what we are looking forward to. Yeah.
Thank you so much, Petal. As we wrap this up, Mr. Oban and Mr. Nadkarni, your final comments before Anisha can summarize and close this. First, Mr. Oban and then Mr. Nadkarni.
Well, firstly, I just want to thank you for organizing this panel. It was great, great to hear everyone's thoughts on this. So while I agree that, yes, there's quite often we don't implement the provisions we already have, but at the same time, I think we are at a spot where if we don't try and either through creative interpretation or through an amendment to our statutes, if we don't grab this moment and create opportunities in the digital space, I think we'll end up missing the whole race by a decade or so. And I'll just leave it at that for today.
Okay. Final word. We started with you, Mr. Nadkarni. You have the last laugh, so to say.
Thank you. So it's been a pleasure speaking to all of you and sharing the thoughts. Very insightful discussion, yes. Just to add to what Amit was saying on the NFT part of it, NFT I think is really, a new mode of exploitation as opposed to a new work per se. So it only kind of enables a person to hold maybe the property. It may not give you any rights at all. And as Amit was saying, I think, and even Isani's just now, the Copyright Act really talks about all of this today. It talks about all forms of works. So the song and the music album that Isani's was talking about, that's your work. It's converted into a digital file and is tracked in its in its entire life, where it's going. So that's what an NFT is really. So there are no special additional rights which are required to be incorporated into the act. It's only implementation of what already exists.
Thank you so much. There have been two questions. They've been answered by some of our panelists while they've been speaking. There was a question from Sonam Mittal. How would user-generated content be treated by the courts? Consider contest posted by an advertiser, asking people at large to create content using their product. The best videos wherein would be shared on the advertiser's social pages and website. How would infringement be treated there? So Sonam asked that, and Nishad has answered that beautifully. The terms and conditions of contest by the organizers of the contest normally contain aspects about ownership of content that is created or a license to use the content in any manner as they want. Terms relating to use of original content as well as the indemnities from time to time. So that's been answered. There is a question, another question from Advocate Ramachandran on the section 47, 48, 92 and 100 in the Patent Act. We leave it at that, but we're grateful to all our panelists and every Saturday from 12 to 1 or 12 to 2, depending on the depth of the topic, we will be doing a BW Legal World live every Saturday, taking up one issue. We started with an IP issue, and BW Legal World had the webinar live award from the attendees on the Zoom, our Facebook page, Twitter page, LinkedIn page, our Business World site, which gets about 32 million traffic in a month on an average, had this live. As I said, it's early days for BW Legal World. This is the 20th month of the entity, but I think we've been able to establish, thanks to patronage from people we've been able to establish some kind of impact in this domain, and we look forward to engaging with all of you in another BW Legal World live next Saturday. Next Saturday, we'll be taking up issues that impact public health policy. Public health is becoming very important, and litigation around public health. The pandemic has thrown health and healthcare issues right up front center, and we will be discussing what are the implications for public health litigation and public health issues. So just want to share this with viewers and people who are tuned in. I'd like to express my gratitude to Mr. Abhay, to Mr. Oban. And Mr. Oban, both your first name and your second name are novelties. This is the first time I came across both of them. So I must mention that, and good to meet you virtually, and hopefully I live in Delhi too. We can meet in better times when you're back here. Thank you, Mr. Datta, for being provocative and very real. Thank you, Ms. Petal Chendiok, for bringing in your experience. And last but not the least, thanks, Mr. Nadkarni, for again opening the webinar and making the comments that you did. Anisha, I'd hand over to you to sum it up. And I'd also like to thank my colleague, Mr. Krishnendra Joshi, who behind the scene works very hard editorially on making sure that we stay relevant and we are first on a lot of things. And my colleague on the business side, Garima, whose idea it was to put this. We are missing Ashima Ori, but I'm sure she'll be back next Saturday. So back to you, Anisha, to sum it up and wrap it up.
Firstly, thank you to all the speakers, Mr. Ndok, Mr. Oban, Mr. Abhay, Mr. Datta, and Mr. Datkarni for your time and for all of your insights on copyright matters this morning. I'm sure the audience was extremely engaged and found this to be a very informative session. As Dr. Batra mentioned, that every Saturday, BW Legal will be hosting a session on relevant legal matters. So we are looking forward for the audience to join us every Saturday from 12 to 1 o'clock. Thank you so much for joining us this morning. Have a very pleasant weekend. Thank you so much.
Thank you. Stay safe, and we look forward to engaging you soon enough, both virtually.
Thank you.
Thank you so much.
Thank you so much.
Appreciate your
Dr.
time. Appreciate your time. Thank you so much.
Thank you.
Thank you.
Thank you.
Have a great day, guys. Bye.